I guess we'll go ahead and get started, and that will attract some of the other 60 people who are registered for this pre-colloquium workshop. Welcome to Maryland. My name's Bob Percival, and it's really a pleasure to have you all here. 25 years ago, we started the environmental law program here at Maryland, and the very first thing that I made a priority was to start an environmental law clinic. The reason I realized why that was essential was because I had started practicing environmental law with a public interest group without any clinical training, and I had to learn by doing it, and I found that the next generation of students should not have to do that. And so we started our clinic at Maryland. It's now become an incredibly successful clinic, as indicated by the fact that this year it's going to receive the ABA's Award for Distinguished Service in Environmental Law and Policy, the same award that the IUCN Academy of Environmental Law won last year. When our clinic started, there was not a lot of international environmental law work going on with respect to law school's environmental law programs. But that soon changed. In 2002, we were asked by the University of Chile to help them set up South America's first environmental law clinic. That was quite extraordinary at the time because it was a government institution, and what had happened was they realized the importance of free trade for the Chilean economy, and they didn't want to give other countries an excuse not to trade with them by thinking that their environmental standards were too low. So they thought one way to improve their standing in the world was to have an effective environmental law clinic at the premier law school that had educated every Chilean president except for President Pinochet. And then, as a result of that experience, we decided in 2007, on the 20th anniversary of our environmental law program, to sponsor a conference on globalizing clinical education to protect the world's health and environment. We brought together representatives from 13 countries to brainstorm about how to create a network of global environmental law clinics, the very idea that's going to come to fruition here today with the Academy creating such a network. So I wanted to start by showing a brief video from that conference that our global environmental justice fellow, Zoe Fulham, put together. You'll note that some of the people from today were here at that conference as well.
Participants learned about similarities and differences in clinics around the world. The increasing number of countries requiring students to participate in the clinics is evidence that their importance is growing. From Chile to Israel, law programs require students to participate in clinic time. In India,
no, they are required, but there are, so far we do not have any specialized clinics for environment as such, but there are environmental law cases that have come up. But two of the law schools, they are planning, and maybe in the near future, they'll be setting up environmental law clinics.
In China,
in our university, and each semester we have 90 hours for the clinical.
In Costa Rica,
the idea is that this 300 hours created by this last law that has the obligation for the student in a pro bono way of having 300 hours of community social work. We linked it with the consultorio and with the houses of justice.
All around the world, the demand for clinical legal education is on the rise.
September 2000, clinical legal education programs were offered by 7 law schools of Chinese university. Yeah. Now, the Committee of Chinese Clinical Legal Educators have 65 law schools, and
this global effort still faces challenges. Many clinics are not yet strictly environmental, and other programs have not yet developed due to inflexible credit standards. Despite the differences in global clinical models and participation requirements, we face the same challenges, such as balancing teaching and clinic responsibilities.
But our students have almost know the skill, so our professor or the teachers will spend much more time than the other professors.
High clinic costs are also a problem.
For example, a university take one clinic course need $20,000 US 1 year.
Another issue we identified was the limitation the academic calendar poses on clinic work.
Clinics run on semesters, law schools run on semesters, the real world doesn't. And that's, I think, the most difficult part of our job as clinicians.
Cases are long-term and don't fit in the semester schedule.
The whole issue of what do you do with your clinic in the summer when all your colleagues, at least in the United States, are off on vacation or in the library writing articles. What are you still doing? Because most academics in the United States that aren't clinicians are on 9-month contracts and have the summer, in theory, off, but sort of off to do their academic research.
This problem can have an effect on the student experience.
I think it's very important that students will learn when they accomplish a mission and what are the results. Most of the environmental cases are not solved within 1, 2, or even 3 semesters, and that's a very known problem that was here.
Similar goals and obstacles of clinics represented prove that collaboration is important, especially in helping to create and aid with the growth of new clinics.
I was thinking about the group that will identify the regional problems and make suggestions on how we should develop clinical legal division relating to environmental law in these regions. And then by the time, and maybe plan ahead for a future colloquium where we're all going to get the representatives of these different regions together. We'll now do a map to know how far we have gone in developing clinical legal division relating to environmental law in the world.
Other solutions pointed to building upon networks, such as with well-established environmental NGOs to support clinics. Models of clinic funding through employing grad students were especially exciting to some international guests.
And that there is no single site you can go to that has an overview of all of the environmental NGOs around the world. And I was wondering if, as a starting point, we might not ask the University of Maryland Law School to start up a site that just lists those environmental NGOs that people in this group have been involved with, and maybe see if it isn't possible to start creating an internet network.
The 2007 conference explored the globalization of environmental legal clinics and the common issues faced around the world. From here, we can identify the progress that needs to be made and move forward. Thank you for attending this year's conference and today's workshop.
And that's one of the reasons why I was so delighted when Maria Marquez last year suggested that this workshop be held. And I want to turn it over to her now to begin today's workshop.
Thank you, Bob, and congratulations for that great video. So good morning. First of all, I would like to say that my main problem today is that English is not my first language. So I'm the only speaker today that who has not English as first language. I'm going to be the worst speaker in that sense. And I have a second problem. It's Sunday morning. I'm not able to speak in the mornings, even in Catalan, which is my language, and specifically on Sunday. So if I don't find the word, please feel free to help me. So this first panel, which the title is Global Models of Environmental Law Clinics, has the goal to introduce you on what should be the role of clinical legal education on the academy. And then we will have two case studies presented by Will Amos from the University of Ottawa and Kim Connolly from the University at Buffalo. I'm the co-chair of the Teaching and Capacity Building Committee, and I am also director of an environmental law clinic in Spain, which has only, clinical legal education in Spain, it's quite new, so the clinic is also quite new, only 7 years old. Well, as probably many of you know, the Teaching and Capacity Building Committee submitted a strategic plan to the board of the Academy last year, and we thought that it was a great opportunity to develop a clinical and environmental clinical legal education project. This is one of the streams of the Teaching and Capacity Building Committee, and you can see here the objective. It's promoting clinical legal education in the field of environmental law and the specific actions of we can develop within this project. We thought that it could be interesting to identify environmental law clinic legal education programs run by academy members. That's why we circulated a survey some weeks ago. We had some responses. We are sure that there are more clinical programs within the academy, so this is only a starting point. And we would like to identify the members, the programs within the academy to create a network of environmental clinical legal clinical education programs to share experiences and materials and to collaborate in international cases. When I talk about collaborating in international cases, we mean not only sharing cases, but only having partnerships. We know because in the clinic in Spain, we work with Latin America countries, and it's always very difficult when you have a client very far from your university. Sometimes it's very difficult to get in contact with the client, specifically if they are communities. So if we can have a network where you can find partnerships all over the world, maybe we can work together in that kind of cases. And we can also share cases. We think that this is going to be very challenging for all of us. So this is one of the specific goals of this strategic plan of the Teaching Capacity Building Committee, creating this network. I will come back later to this point. We thought that it's all important to promote new clinics and provide training to new clinicians and to new clinics, and probably the annual colloquium will be the best place to do it. This is going to be the first workshop, but we would like to have a workshop on clinical legal education every year and to develop all these matters. We would like also to promote activities where students are involved. This was one of the concerns of the Teaching and Capacity Building Committee from many years, I think. And as all you know, clinical legal education is also a great opportunity to get students involved. And maybe we could get presentations from students, clinical students in further workshops. And finally, and I think that this is strategically for the academy, we would like to encourage law schools and research institutions that currently run an environmental law clinic to join the academy if they are still not members, by often being part of the network. So it can be also a way for attracting new members to the academy. So all that are obviously benefits for the academy, but I would like to point out only some ideas, but what are the benefits for faculty and for students developing clinical legal education within the academy? I know that mostly in the United States, where the clinical education is more developed, that it's a big difference between academics, traditional law teachers, and clinical faculty. If it's not so, please tell me, because you know much better than me. But I could learn that this is a difficulty to enhance legal education. We think that the profile of the scholars of the academy, so that means all of us, it's mostly the law teacher, the traditional law teacher, more than academic point of view. For us, thinking from that point of view, it's also an opportunity to get involved with clinics. We have to be aware that there are not only litigation clinics all over the world, that an academic maybe has not a very big role in a litigation clinic. Not always, but but there are also policy clinics which are more linked to research. So, or mediation clinics that are also very linked to research. And this is a way to go to clinical legal education. Clinics can provide us a cross-functional approach to environmental law. That means, from different teachers from different branches of the law, criminal law, civil law, administrative law. I don't know in your countries, but sometimes we only work on our field and we don't work as a team working on the faculty. So this is a good point, because environmental issues are always cross-functional. So it's a good opportunity to work together with other colleagues in the law school. It's also a good opportunity for an interdisciplinary approach to environmental law. And with this point, I mean other fields, engineering, maybe chemical professionals. All we know that when we work on environmental cases, we need someone to maybe measure the pollution, and law students can't do that. So it's a good way to work in an interdisciplinary way. It's also a good opportunity to develop environmental justice. All you know that environmental justice is not the same of environmental law, and it's a developing field for research for many academics. So, and it's a good opportunity. It's also, it can help us to expanding legal knowledge when we are collaborating with clinics from other jurisdictions. So it's a door to comparative law also, if the clinics. And it's a good way to share experiences and challenges that we have to face with our work. For students, clinics have the benefits of clinical legal education. I'm not going to introduce all the benefits. We all know which are, and we don't have time for that, but they can get the benefits of clinical legal education. They have also an important benefit when collaborating in international cases. We know that the market now demands the ability to work in international context, so we have to develop strategies to let students work also in that way, and they can get involved in the activities of the academy, which is also important. Our starting point is, as we could see on the video, that clinical legal education has gone global. I took this book only as an example, but it shows how is everything developing. I don't know if you know this book, but I highly recommend you. There's different chapters from experiences from all over the world. Obviously, United States, Britain, Canada, and Australia are the pioneers of clinical legal education, and so they have the history and experience, the background. But now we have also experiences in Africa, Southeast Asia, and India, Central and Eastern Europe, Latin America, China, Japan, Spain, and that's not all. So this is our starting point. And the lessons learned from all that initiatives that, from the point of view of an international approach, people can realize is that there is a variety of different types of clinics and clinical courses. So this is a quotation of that book. What is important is that all that programs have to be linked to the social action and offer experientially based training in professional skills and values that emphasize critically important areas of professional and public interest that have been left out of the traditional law school curriculum. But the models are very different. So we think that everyone is welcome on the network of environmental law clinics in the academy, and I put here some concepts that you can find when you see what clinics are running on all over the world, and we want to be inclusive and take also live client clinics, simulation clinics, legal literacy and industry law programs, in-house clinics, extensive programs, internships, placements. I have to confess that I don't know yet the difference between an externship and internship, but I guess that someone will explain me because I'm really not sure what's different between an externship and internship. It's maybe only the point of view of where who's sending or receiving, but I don't know. But there are some universities I could check that they have extension programs and internship programs. So I got confused because on-campus clinics, off-campus clinics, there are also clinics based on NGOs. We'll talk about that after my presentation. Litigation clinics, policy clinics, mediation clinics, interdisciplinary clinics. Everyone is welcome to this network of the academy. That's why the teaching committee suggests using the more inclusive concept of environmental law clinical legal education programs, not clinics. Because if we use environmental law clinics, maybe someone can think that only those universities that have a clinic itself with a staff, with a building or with a room and a specific structure can join the network. And an externship program, it's also clinical education, and we would like to include it. And finally, I would like to show you the point where we are now. Is Laura Stone here? Oh, Laura. I would like to thank Laura because she has helped us with the map. We have tried to put, well, the wall is very big, but I will try to, yeah. We have tried to put on a map all the environmental law clinics we could find, and then we put them on fuchsia, the ones who are members of the academy, and in blue, those who are not members of the academy. Our goal is to turn blues to fuchsia on the future, just convincing all that universities that the network can be useful and helpful for everybody. So the teaching committee think that the next step should be to develop this network, to set up its goals, to set up how can it function, and to establish a specific committee to develop this project. Just to show you, you have here, because as you can see, the most of the clinical programs are in the United States, which it makes sense because of the history of the United States on clinical legal education. But we know that also further clinical programs on the environmental law field, and our goal is just to make them know that we exist and that we can develop a very challenging project together. So that's all, I think, from my part. So now it's, well, sorry. This map, I think that could be available on the net. Yes, we could publish the map on the web of the academy so everyone can check if it's there and just to suggest new programs. So thank you for your time. I think that now what is really interesting is to hear about the experience of Will and Kim. Will in Canada and Kim in the United States. Will, it's your, yes.
Thanks, Maria, and thanks particularly to Bob and to Jane and everyone here at the University of Maryland Law School. It's a really fabulous opportunity to meet many of you. We in Canada, at least at the University of Ottawa and at the Eco-Justice Environmental Law Clinic, where I'm director, we don't yet feel integrated into the global community of environmental law clinics, and we want to be. And this is a great first step. I was really happy to hear about the 2007 initiative. It seems as though there have been a lot of people sort of feeling that desire to bring the global environmental law clinic community together. And this initiative, thanks to Maria and thanks to the Academy in general, has been a really positive step. So what I'll do is, I've got a funny feeling that I'm going to be for many jumping back several years, jumping back even 5 years, and providing the kind of statement that might have been made back in 2007. But I'll try and also build on some themes that have been mentioned. One being interdisciplinarity, and I was struck by that map that Laura presented, because if Maria hadn't made her comment about the dominance of the U.S. environmental law clinic movement in this global picture, it might have been easy to look at that map and think, well, there are a whole lot of clinics in Canada because we're sort of just hiding on the other side of the border, whereas in fact there really are only two, and there may be a third in the offing at the University of Sherbrooke in years to come. But it's really striking, in fact, that in a country with a common law tradition, with a generation and almost a generation and a half now of environmental law protection, governance, and litigation, of course, it's interesting that there are only two. would be very curious to know if Calvin Sanborn and the team at the University of Victoria's Environmental Law Clinic were in attendance in 2007, but I'm getting ahead of myself. So to introduce, my name is Will Amos. I'm the director of the Eco-Justice Environmental Law Clinic at the University of Ottawa. And we call it the Eco-Justice Clinic because it is established as a partnership between Canada's leading public interest environmental law organization, which is called Eco-Justice. Eco-Justice is a charity. It has offices in Vancouver and Calgary and Toronto, and thanks to the partnership with the University of Ottawa in the nation's capital. Eco-Justice, and this partially probably explains part of why the movement of environmental law clinics has been so slow to develop in Canada, and that is that the public interest environmental law movement in Canada itself is not that strong. It has a long and rich tradition. There are several organizations who've played a part since the 1970s, but there are probably about 25 lawyers in Canada who consider themselves practicing public interest environmental lawyers. And there are, I think, five individuals who are practicing public interest environmental law clinicians. And I include them in the group of public interest environmental lawyers. So you get a sense of just how small this community is. And the partnership that was established between Eco-Justice and the University of Ottawa, which is obviously, an academia NGO collaboration, and this sort of species of engagement between different sectors is not foreign to the U.S. experience. I understand there are a number of these with NRDC, with Earth Justice. Some have resulted in successful long-term collaborations. Others have resulted in a parting of ways after a series of years. But in Canada, it was the only way that one could continue building the environmental clinical law experience for students, to make it more available, was to do it through such a partnership, because it is very expensive. And universities across, law schools across Canada call us at the clinic and ask us on a regular basis, how did you guys make this happen? Who is putting in what funds from both of these institutions to make it work? I think the simple reality of the cost structure is such that it makes it very challenging to bring the limited expertise that exists in Canada around public interest environmental law litigation and law reform, and to bring it to bear for the student experience. So at the Eco-Justice Clinic at the University of Ottawa, the only reason it got off the ground was because there was significant foundation funding to make this partnership, to create the glue for this partnership. And thankfully, over a period of 5 years, there's been some learning as between the two institutions. So I think that one of the big lessons that we've drawn in Canada is that clinics don't just pop out of the ether. They require the building of a relationship, and where that relationship doesn't exist, as between, say, Eco-Justice and the University of Ottawa, which really didn't have much of a, any particular institutional connection, it takes individuals moving a ball forward, finding funding, and developing a circumstance where they can actually see their mutual self-interest in maintaining an initial investment that's made. Of course, when you have an NGO and academia collaboration, you end up with tensions, and interesting ones, because the exigencies of a nonprofit that operates with a very small budget. Eco-Justice, as I said, has 4 offices, but we only have 16 lawyers and annual revenues of just under $5 million. So this is a small organization. When one compares it to NRDC here in the U.S. or Earth Justice, these are much bigger organizations. So for Eco-Justice, it's easy to feel swallowed by a bigger institution. The University of Ottawa is a very big institution. So it's been a process to build the trust between the two organizations, to build an understanding of what it is that Eco-Justice appreciates from the University of Ottawa, and what it is that the University of Ottawa appreciates from the Eco-Justice culture. And I would suggest that at the beginning of the relationship, the primary benefit that was perceived by the university, beyond the student experience, which is obviously very important, was the name recognition that Eco-Justice could provide. Every university that is competing in the marketplace for students interested in environmental law will appreciate the positive publicity when their school is involved in a high-profile case. And so that was, I think, the initial impetus, the student experience, as well as the benefiting of being on the national stage. That was the benefit for the University of Ottawa. But over time, I think that there's been a maturation of that perceived benefit to the point where, and I'd like to sort of shift emphases here away from the institutional partnership and more towards the interdisciplinary angle. Now, I have much to learn from Bob and the experience at his clinic because of the interdisciplinary work that they've been doing. We thought for a while, and this speaks to the isolation that we've been living in at the University of Ottawa's at our clinic, because we haven't been integrated in this global community. We didn't know that there were other interdisciplinary clinics, but we're very proud that part of the institutional growth that has occurred as between Eco-Justice and the University of Ottawa, that part of that growth has now become a new and a different partnership as between Eco-Justice and the Faculty of Science at Ottawa U. So a whole new stream of science students coming online in 2013, some of whom will be integrated with their law student cohort, and every year building in a series of different initiatives and different opportunities. The Eco-Justice is not just a public interest environmental law organization. There's a whole science stream to the NGO itself. So bringing that aspect of expert science advice in the service of law reform in the service of public interest litigation. That has always been part of the eco-justice portfolio, but it's never been the dominant part. And there have always been we've now got 3 scientists in the entire country for an organization. It has always been a pressing need to find more resources, to hire more scientists, to provide more expert advice to more community organizations. Well, finally, eco-justice realized that it didn't necessarily have to go outside of its own sphere to build that expertise, and it started looking over to the University of Ottawa. And of course, at the University of Ottawa, as at many schools, there are a lot of experts within faculties of science, engineering, that are capable of bringing great depth and experience to many environmental law reform and even litigation issues, particularly if they have expertise around evidentiary issues. So the NGO that I am, who is my employer, Eco-Justice, has seen, beyond its initial perception of benefit, has grown to appreciate that the University of Ottawa's expertise can actually bring all sorts of networked opportunities to grow in areas where it lacks internal expertise, and it opens all sorts of new windows for collaboration. So as we integrate science into the Environmental Law Clinic, and it's still a work in progress, we're challenged as clinicians, of course, to develop a new approach to teaching that integrates both. But at the same time, I think we're also realizing that the way we teach law students how to engage in public interest environmental law, that also changes, because I don't think we're particularly interdisciplinary in how we approach the law side. But now that we're looking at the science side and teaching students who don't have a background in law or governance, politics in general, how do we teach them? We ask ourselves. Well, I think that challenges how we approach the law student pedagogy side as well. I do want to leave. Some extra time to allow our hosts to feed into this discussion. I mean, we're supposed to end within an hour, so I'm going to cut myself a bit short so that there's hopefully some opportunity for questions and comments at the end of this. I feel that there's a rich experience that would be gained if we added that, but. Since we were established only in 2007, and since the other Canadian clinic, the Environmental Law Clinic, or the Environmental Law Centre, UVic, was only established a few years earlier, the Canadian Environmental Law Clinic tradition is it's still just really in its incipient phase. It really has not flourished. And I think that there are some interesting cultural and legal tradition reflections that are worth putting on the table. Certainly, Canada is a less litigious culture than we find here in the U.S. The statutes, the environmental protection statutes that are on the books, whether they be provincial or federal or territorial for that matter, they're typically not written with citizen suit provisions incorporated. They don't provide for as many opportunities for judicial review, since most statutes are written to grant the executive, or in most cases the minister, all sorts of discretion to implement or not the protection provisions in the law. This is obviously a problem that goes deeper than what can an environmental law clinic or public interest environmental lawyers in general do, and what can we do to protect the environment using the law. But I think that that's one of the underlying reasons behind our lateness in arrival to the game. It's simply that the tradition of litigating to protect the environment has never been as strong or as deep as it is here in the U.S. And that's not. I don't think that's not changing in the foreseeable future. There's still. It's still a much smaller public interest environmental law community in Canada, and we're still, I guess, growing into the field. Although that isn't to say that we don't have problems of a scale that aren't worthy of throwing another army at the issue. So. I think I'll stop there. I appreciate the opportunity. It's a real pleasure to be here, and I really, I hope that I'm able to meet as many of you as possible. So please do give me the opportunity to learn more about the institutions you're involved in, particularly the environmental law clinics. Thank you.
Hi, I'm Kim Connolly, and I am delighted and humbled to be here. And I have a big job here. I am former president of the Clinical Legal Education Association and have taught an environmental law clinic for over a decade. And I'm supposed to give you a little bit of history of all clinical legal education in the U.S., just to kind of contextualize it, and then boil it down to what's going on with environmental clinics in the U.S. And I also wanted to add just a little bit, because I thought it would be helpful to talk about adaptive ecosystem management. Now, how do I make this go ahead? How do I make it go forward?
Yes, I have the same problem.
Okay. So I just said that. I was thinking. So anyways, we have a lot of clinics in the United States, and that's in part because of what we've been doing here for many years. We started in the late 1800s with voluntary legal dispensaries that showed up in some clinics and in some schools, and then they started saying, hey, how about if we give some people some credit for their coursework? And so in the early 1900s, started exploring that, and then back in 1921, the Carnegie Foundation said, hey, it'd be really good if some students got some practical skills while they happen to be hanging out at law school, and then in the 1940s, the Association of American Law Schools said that current case instruction is somehow failing to do the job of producing reliable professional competence, which of course is what the Carnegie Foundation Best Practices said many, many years later, but we have to talk to ourselves a lot about needing this in order to get where we need to go. So then some law schools started having some small experiments in applied legal education. Most of it was non-credit bearing in the beginning, and then in the 1950s, there really was a focus on legal services to the poor, and they started having some formal clinics. And it's very interesting to talk about the folks who started these, and then the 60s, the hippie type of thing. My kids say, "You're a hippie, mommy, and we love you because of that." so even though I was born in the 60s, so all of a sudden we're doing more. We've got this increasing attention to social justice, and so clinics start popping up more and more, or refocusing some of the work that some of those existing clinics were doing. And then in 1969, some money showed up, because money always helps, right? So the Council on Legal Education for Professional Responsibility said, applied legal education effectively places practitioners to be in the chaos of real life, and talked about really how that was going to work. And as many of us know who teach clinics, and I teach clinics and other courses, there's nothing that compares to something real going on with a student. I mean, I do lots of great simulations courses, but the real stuff, just the chaos of real life. I love that quote. And so the Council, CLEPR, the Council on Legal Education for Professional Responsibility, spent millions of dollars to operationalize clinics across the nation. And then Congress showed up with even more money and allowed millions more to go and really create clinical legal education around the country. So lots of the people, it's very interesting because we are now having our first real generational shift of folks in legal education, clinical legal education in the U.S. who are retiring, who really started with CLEPR money. They've done their whole careers and they're retiring. And as you said, There's been some class issues. A lot of those folks came in and they're on contracts. They're not tenure track. There are issues there. But there's been a lot of work on that as well. But we've had some generations to work on this. So we had a lot of, by 1975, we had a lot of schools offering some sort of course. And then all of a sudden, we had these people who were in the academy, and as you're talking about the attention of being in the academy, a lot of these people came from practicing in the world, but they're like, hey, these people who are across the hall from me, they're writing, maybe I should write too. And so the birth of clinical scholarship started. And then there was a report called the McCrate Report that said, we need to do what kind of echoed the 1944, we're really not creating practice-ready students. Then we created the Clinical Law Review, and then Carnegie and Best Practices said, hey, hello, we've said this before, but really not creating practice-ready students, and so we're working on that. And then there's a wonderful group, the Center for the Study of Applied Legal Education in the U.S., that Bob is one of the leaders of, that shows that at this point, all but a few law schools offer in-house clinics. Now I'm going to kind of move to environmental, but I'm going to just spend a second going over how I conceptualize environmental clinics, because I think of them as an ecosystem. We all know, we're environmental people, we all know ecosystem. It's an interaction of a community of organisms. So I love hearing about what's going on in your clinic, what's going on in your clinic, because we all function within our own distinct ecosystems, and we all have to function when we are doing our clinics with our own set of adaptive management. We have to make decisions based on what's going on in our clinics and make ongoing changes to what's going to be best for our clients, our students. To the extent we have clients, sometimes we're working with skills and you're talking about, I like the broader view, but we're all in a functioning environment of we have to adapt to where we are. And so then, if we wanted to do all this, if we wanted to, read a law review article, because that's sometimes what clinical people do, we can get into all this stuff about, really analyzing through ecosystem management principles how we're doing in the clinical world. And as I talk about this model, I've started talking about it just with environmental clinicians, but as I talk about the concepts of public participation and integrating research and doing all these kinds of things, my non-environmental clinicians say, oh, that's us too. So it's really wonderful to use this concept from my perception to reach out to the broader clinical community to kind of say, okay, we're going to plan, we're going to act, we're going to evaluate. This is what clinicians do. This is what we train our students to do, to be reflective practitioners. And that's really adaptive ecosystem management. And then we can also use models of how we can assess. But I'm gonna move on so that we can have discussions. But if you want to go look at this stuff or talk with me after, I would love to, because I think this provides a real framework for us to help people within our academy, within our ecosystem, who aren't we clinicians who I just find near and dear in my kindred spirits, help them understand how we fit into the larger world. This is one of my favorite quotes by one of my personal heroes since I started teaching and before. At Georgetown, Hope Babcock has said, the primary mission of clinical faculty is to create visible models of justice in action, demonstrate deep commitment to achieving justice and challenging injustice. This doesn't mean that all clinical programs will be alike, so this goes back to Maria's point. So here we are. We've got almost 40 environmental clinics in the United States of America. Over a third of them are at state schools, like mine. I'm at SUNY Buffalo, and before that I was at the University of South Carolina. We have somebody from Oregon here who started, the very oldest, and then the 80s had some birth of them, and then there was a whole bunch in the 90s, and then the 2000s. We're kind of keeping track of making more and more of them. They really differ in how they're designed. Some offer just 3 credits, some offer up to 12 credits, basically close to everything that a student takes. Sometimes students, they're very small professor-student ratio, sometimes there's large. How they're designed, are they focused on litigation, are they focused on something else? That's all really different. And how they're funded is really different. Some places, like my school, is all hard money. I'm not expected, it's nice if I bring in extra money, but they fund us, we're hard money funded. Other schools are soft money funded, so you really have to figure that out. And so our fee awards part of it. And as I said, faculty status varies. I have tenure, lots of other environmental clinicians don't, and actually don't want it, because they don't want the stuff that goes with tenure, such as all the myriad committee meetings and all the stuff that you have to write with footnotes that they believe people don't read. My mother reads my law review articles, so, at least somebody does. So anyways, Here in the US and around the world, we've got all sorts of models that we can look at. And so as we're building this new framework, we can look at what the richness that we've had here, both within the environmental community, but also from way back when, to how you can really enrich clinics, starting from litigation, which is what a lot of people think of, but also I've always done more policy-based focused clinics, in part because I always have to teach other classes. When I was at the University of South Carolina, the clinic was one of 5 classes I was expected to teach a year. So I couldn't, and I didn't have a staff attorney, so there's no way I could take on huge litigation. I had to take on things that would stop and let me do the other work that I had to do. Some focus on certain things, some focus on certain clients, just kind of represented clients. There are some interdisciplinary clinics, and there's some that have some out-place and in-place hybrid models. There's lots of ways to do it, and we need to nurture and figure out, once again, best within your ecosystem. Do adaptive ecosystem management for you. When you're looking at clinics in the U.S., you see that this is a very small. I know this is PowerPoint 101, don't do this. I'm sorry, that's so tiny. But when you see the wonderful work that the Center for the Study of Applied Legal Education did, you see that environmental kind of falls right in the middle. There's some that are huge numbers, but we have a healthy percentage of folks. We're really strongly in there, the environmental clinical world, and expected to be present and active in the larger clinical community. What makes it successful? How the instructors work? Is there sufficient institutional support, financial and otherwise? What if you get in trouble? We're going to hear about stories of folks that get in trouble, and do people have your back? Choosing clients and projects. How you design it. I don't use the word pedagogical. As a matter of fact, I use Frank Bloch, who wrote that wonderful book, is one of the people who uses andragogical, the teaching of adults. But how you design your teaching methodology. Where you're located, your attitude about clinics and environmental law, and outside forces all can really play into basis for successes and challenges. And there have been places that have had clinics that have not lasted, and there have been places that have had clinics that have had to vastly change what they've done, in part because of a lot of these models. And I just want to close very briefly with telling you what's going on with me. I arrived at SUNY Buffalo Law School, and I came in as the overall clinic's director to a place that had a very wonderful environmental clinic. Actually, there also was a kind of an energy law clinic, and the gentleman who's running that has since retired. But there's a wonderful, wonderful environmental clinic that's been being run for 30 years by somebody who's about to retire. And so I didn't want to come in and say, hey, you have to run it my way. And so I didn't want to have him co-direct in his last few years. So he's just off doing his thing, and of counsel, I show up a little bit, but I don't co-direct with him. But I've been anxious to do some clinical stuff, so I am now closing in on starting a very specific type of clinic, which is a healthy homes legal clinic, working in conjunction with our U.S. National Green and Healthy Homes Initiative to work on bringing together housing issues that people are facing in their homes, such as lead, mold, asthma, all sorts of stuff, and actually working with the students to be working in housing court and elsewhere, and doing some interdisciplinary work, but really focused on making sure that the homes and housing is healthy. And Buffalo has old housing stock, people are living in terrible conditions, and so it's one of the things that we can do that's kind of a really focused down. If you told me a couple years ago I'd be working on this, and I'm going to have 3-year funding, and then we're going to our goal is to have this happen and then move it off into something that we can have students then partner with pro bono folks and not have it be a clinic forever. We're kind of a design mode clinic. So it's kind of fun that we're going to do this. It's an example of adaptive ecosystem management. Again, I'm coming in, I'm kind of doing something, and then I'll get to go back, and then by then my colleague who runs the environmental clinic will have retired, and I'll take over formally the environmental clinic, and then I will get to do what I've always longed to do, which is a little bit of international work. So I want to turn it over to discussion. I want to apologize also in advance. I'm leaving today because I have to rush back home to Buffalo because I'm flying to Bucharest to be on the part of the U.S. delegation to the Ramsar Conference of the Parties. So find me today or find me later, because I'd love to chat with a lot of you, and I hope to see some of you this morning, but I have to go off and go do wetlands work too. So thank you.
So, thank you, Will and Kim. We have 10 minutes for discussion. Is there anyone who has something? Yes, please, Ben.
I really enjoyed all three presentations. I'm wondering if you've got any advice for a law school that is not in a position to launch a full clinic or full externship program, yet on the other hand wants to provide some kind of experience for students that has elements of this. Are there other models, other kinds of ways? Is there any advice that you can get? Because I think everyone in the room would love to have all of their law schools to provide that, but of course it's a very substantial commitment, particularly if it's a live walk-in clinic. So I appreciate any advice.
Thanks for the question. I'll start by looking particularly at the Vancouver example, where there's such a, I mean, in the west coast of Canada, that's where the greatest concentration of public interest environmental lawyers reside, and there certainly are opportunities. One would immediately think, well, why doesn't a university partner with an NGO and see what kind of, like, for instance, West Coast environmental law, and why not engage with them? From the NGO side, and I can speak with experience on this one, the NGO says we're already under capacity. Taking on volunteers from a law school on its face seems like a great idea, but then the management requirements and the engagement that those students require ultimately ends up eating away at their own productivity on work program. So that's not, it's sort of a facially good solution, but I don't think it's the answer. I wonder if there aren't avenues for partnerships with municipalities. I haven't seen a lot of this, and I don't know what experience there's been in the U.S. But this Healthy Homes initiative, or the Healthy Homes Clinic, seems like a really interesting example of a very municipally focused, a very locally focused environmental law clinic experience. And certainly what we see across the country in Canada are disputes as between local residents and developers over project X, Y, or Z, and the courts and tribunals are jammed with proceedings that are not particularly well informed, that last a long time, and that ultimately that often don't end up with positive results because they aren't, they're not guided by competent counsel or anyone with any particular legal expertise at all. So I wonder if there isn't room for a broadening of the idea of what would be an environmental law clinic. I think a municipal law clinic could be something that a university might take on with an environmental component. I think it's sometimes thinking within that environmental box is what can be the most limiting factor.
There's another maybe startup option that might be interesting to you, I don't know, which is I always worry about getting students involved, and then under New York law there's student practice rules and making sure that they're not kind of violating any laws before they get to sit for the bar. So I always worry about that. So one of the things that I've done over the years is I've had my buddies in environmental law. And when I was in South Carolina, there were precisely 5 public interest environmental lawyers, and by the time I left, and 3 of them had graduated from my clinic, because there were 2 when I started. So there was a smaller group of people, but there were also people who weren't lawyers, but who were in environmental groups. And they always needed information. And so what I started doing is having my students in my seminar do applied legal research. So people would line up, and they'd say, is it time for your class? Is it time for your class? Is it time for your class? And then they'd give me topics. And then the students would do research. I'd say it's not the practice of law, but then I'd make that research publicly available, and it's something that, and the students love it because they're doing something that matters. And the people in the environmental world love it because they're getting answers to questions that bedevil them, that they just don't have the resources to throw at them. So that may be something to consider between the externs when you can't get quite that far.
Can I just add one other thing? At Lewis and Clark Law School, we have quite a few environmental clinics, but we also have something called a clinical internship seminar, which is where students get placed with a bunch of different organizations around a common theme. So we have a criminal defense CIS, we have an environmental CIS, and they work with municipalities, with nonprofits. spreads the students among different entities. They have class time, and the classroom instructor is in charge of making sure that they're getting a good clinical experience and that they're learning some substance about practice. But they actually go in to work with different organizations at the same time. And because it's an internship, you can do it for less hours, which means that the resource demand on the NGOs and municipalities is less as well. So you're basically sort of outsourcing the clinical work to different groups, but you have a single instructor managing it. It's been very effective and very low cost for us. So.
I hit the one, two, three, some.
Right. I'm very interested in your policy clinics. Can you please share your experience with us in regard to whether you get cooperation, say, from the policymakers from the government, and in regard to other disciplines, is there any tension regarding turf interests and so on? How to get this going? Policy clinics.
How it works?
Yeah.
Well, at least in Spain, in our clinic, I don't know in other policy clinics, but policy clinics can work on rule making, legislative drafting, policy development. So what is important here is to have the client is maybe the government or the government, yes. So then you work for the government developing some projects, maybe a model of law. So you draft rules to provide the government with new, I don't know how to explain it. But yes, please.
When I was at South Carolina, I made a point of always having a governmental client every semester, and I learned that from the wondrous Rena Steinzor here, who took me under her wing when I was first starting, who said, if you're going to get in trouble, at least you need to have some people who are in the government in a powerful place to say you do good work. And so some of the things that my students would be do projects for the Attorney General to help them do analyses to get legislation passed, or draft ordinances for very poor counties. And so I made sure that always happened, and that was very effective in when my students were up doing other things for other clients and getting yelled at by big developers or powerful legislators. There was like letters that I could pull out with the seal of the Attorney General saying that we did good work and to calm down. So I liked doing that, but part of the way that I designed it was things that I could also turn over mostly to the students, so that they could be the first chair and really feel the power of that. And that's harder when you're doing the amazingly wonderful massive litigation that many of the environmental clinics do. It's harder when you've got students who are only there for 12 weeks to get them up to speed enough to really take something, whereas drafting an ordinance or putting together a table, doing an analysis of something is something that's more doable.
What about cooperation from other disciplines like the engineers and so on? Is there any sort of tough issues involved?
I will give you an example or two examples for the policy clinics maybe from our clinic. One example is climate change. So local authorities in Spain don't have the competence to legislate on climate change, but they asked the clinic to do a research, what could they do for climate change. So that was a research for the students, but then we provide the local authorities with some ideas how to act on climate change. Another example that links with the second question, it was in odor pollution. Do you call it odor pollution? How is it in English? Smell, odor, how? Not air, smell pollution, odor pollution. So it's a new field in Spain, and the local authorities need to develop a rule on to prevent odor pollution. Then they asked the clinic to draft the rules, the legislation, and then we had to put in contact with engineers. Because one of the things you need is how the odor can be measured. So you have to put on that legislation some things that are not strictly legal. So then you have to have that kind of relation with other scientific.
Thank you very much.
Yes, there's 1 and 2, yes.
Lynn, I was really interested in that history of the clinics in the US, which I wasn't aware of, and it was fascinating. But the thing that really caught my eye was your reference to the funding that was provided in the order of millions of dollars at certain stages in the past. And my question is there still a flow of funds coming from government? And if not, does this mean that funding is essentially the responsibility of each law school to hire the professional staff that are needed? Now, I had a second question for Bill, if I may be a bit naughty, and then come back to that. Bill, like in Canada, in Australia, one of the problems with litigation, public interest environmental litigation, is that when you take judicial review or civil enforcement proceedings in a court, most of the argument is still oral. There are written submissions, etc., but the argument is essentially by high-level counsel who are on their feet for hours putting the case, whereas I think it's a little different in the US system, and that's one of the things I would observe is also a factor. I'm just interested in your reaction to that.
Yeah, you want me to go first? There is no more flow of federal. Sometimes clinics haphazardly get some federal dollars, but primarily it's funded. There's been some interesting developments because the ABA accreditation standards have some mandates with respect to experiential education, and so that has changed the dynamics of what happens within law schools and the need to have folks who are doing clinics or at least externships on every faculty.
Yeah, that to go on, continue on that response, the idea of government funding environmental law clinics in Canada is a pipe dream. In fact, since we're opposing council almost all the time, we're suing them. So our independence at Eco-Justice is guarded carefully. But that the Australian experience, I think, is I'm really glad you raised that, Professor Fowler. I spent a couple of months with the Environmental Defender's Office with Jeff Smith in Sydney this past year, and it's a very different culture, particularly in Australia where there's a split bar. You still have the barristers and solicitors, and so you need to, if you want to appear in court and take matters all the way to trial, you're ending up having to at least have some friendly relationship with high-level barristers who can bring a case. And in Canada, most judicial review submissions are done in writing, and there will be an oral submission at the end of the day, but I mean, most of the work is written, but I think that there's it really does. I want to maybe if I could conclude by shifting back to that earlier question about a policy clinic. The clinic where I work is a litigation and a policy clinic. It comes down to what is one's relationship with the client, and if the client is in this particular case the government, well, that's going to be everything's going to depend on what is your relationship with the government. So when I look at our clinic, we have presently very acrimonious relations with our federal government, which is at this point in time about as unprogressive as they come in environmental law terms. But when one looks to subnational levels, there are a series of governments who are doing some very positive things in Canada, and it isn't necessarily we don't necessarily look at law reform or policy opportunities through the lens of partnerships. We pride ourselves on reading tea leaves of where governments may want to go or where factions within governments may want to go, and figuring out what support they might need in order to bring certain law reform or policy initiatives to the fore. So, for instance, in the province of Ontario, Canada's largest province, there was a recent commission. The Drummond Commission, which was looking at how to reduce government spending overall, and as a product of his report, the commissioner looked at polluter pay issues and determined that there might be some opportunities to integrate polluter pays in a better way, particularly around historic contaminated sites. Well, the government wasn't necessarily going to act on everything that the commissioner had suggested, but there was certainly that opportunity to describe to the government, where they might actually go on in that particular policy or law reform area, and we knew that there would be a constituency open to receiving advice and who would be interested in working with information to build in that vein. So I think in many respects it's a matter of creating an institution that can not only partner with government where the opportunities arise and where there aren't conflicts, but also groups that can actually spot the opportunities for such law reform or policy work and fill the gaps.
Dean.
Thank you. I want to ask a question either to the panelists or to anybody else. And the reason I ask both is either to those in an in-house clinic or a farm-out clinic. And it involves what Kim just said about the first chair. A slight background, I was third chair on an argument in U.S. District Court in California. And after my two students made their arguments, I, of course, knew that there was something more I could add. We always do, right? We are the experts. And so I stood up and said, Your Honor, may I just? And the federal judge said, sit down, Professor. Your students have done a perfect job. Mm-hmm. And as I walked back up the aisle, a couple of lawyers said, those were students? We thought they were lawyers. So my question is this, the tension between wanting to do it right and letting students do it, and the tension in farm-out clinics between what my colleague from Canada just mentioned, getting the job done. The NGO wants to get the job done. They don't want to lose anything, and training the next generation. So that's my question, is navigating that issue, both in an in-house clinic where the professor wants to make it right and yet give that freedom to the student, really to be first chair, not to be a research assistant. And for farm-out clinics, that tension between the farm-out, NRDC, whoever it might be that people are sent to, really just views the student some of the time as a resource. And of course, you hope that you can get them to understanding they're training the next generation. But I want you to talk, if you would, a little bit about that tension, about solving it.
Great question. We live with that. Live with that on a daily basis, and I'm not sure how it's going to work out, particularly on the science side as we develop the interdisciplinary clinic. It's really going to be, I think, challenging, at least at the beginning, to bring science students that same level of engagement in a particular case. I think they will be. It'll be even more challenging to not perceive them as research widgets, or as capacity on the research side. It depends. I mean, the answer to the question, I think, depends in large measure on what are students allowed to do by law in any given litigation file. So in Canada, for instance, they're not allowed to plead, and they have to work with a lawyer, and the lawyer is the one making the representations. Now, this can vary if one is appearing before particular tribunals and they're not engaged in formal legal representation, so there can be variations on the theme. But I think one of the solutions, so this creates a circumstance where it's ripe for law students to not get the same richness of experience by taking the lead and by being the individuals responsible on a file. I think one of the secrets to avoid the problems inherent in a farmed out situation is to, as Ottawa U has done, bring the institution, bring the NGO into the fabric of the university, because I think there's a at least in our circumstances, there's a greater degree of accountability around what the employee of the NGO, the employee of the legal environmental nonprofit is doing, and what work what cases they're bringing, and what student experience they're providing at the university. So in a way, it's as though they're forced to get out of, to shed a bit of their NGO skin and to recognize that they're part of a broader community. That job for me is made quite easy because I have so many strong colleagues, a number of whom are in this room, who sort of, because of the regularized academic meetings, force me to be on my toes and be, talking about not only what files we're running, but what are the students doing? So I think that's part of the accountability mechanism is to bring them in. I'm not sure what the U.S. experience is with farmed out clinics, but I would imagine it's much more challenging when they're on the outside.
Yeah, just a minute. If we want to be on time with the second panel, we should finish with the last question or comment. But I'm very happy to see that there is discussion, because this means that the workshop has future on further colloquiums. Please, Jan. Well, Jane, I thought she was. I thought she was. Yes.
I was going to wait until I was up in front, but I'll answer this question. I think, and I'm going to throw this out as a challenge because it is a struggle that I run the environmental law clinic here at the University of Maryland, and we do complex litigation in addition to counseling and also some policy work. But with the complex litigation, it has been a struggle as to when you have cases that go 2-3 years, how you involve your students. And I've come to the conclusion that my pedagogy is basically premised on 2 principles. There is one that is the observation listening principle. So you learn by watching and seeing the modeling of the experts and then discussing it afterwards. And then there is the doing. And we strive to give our students the opportunity to actually do things. And I'm very happy to say that since 2008, every single one of my classes, we've had students who've actually argued before our Court of Special Appeals. And so they get the experience of actually drafting the brief, and then they're able to do the argument. The appellate work is easier to manage that way because you can take the time to do the moots that are necessary to get the student ready. It's more difficult when you're doing trial work. We had a trial that was scheduled for April, and since I'm a year-long clinic, had it gone in April, our goal would have been to have 1 or 2 of the students be at council table. Well, the trial's now been moved to October. My students come in September. There is no way they will learn enough to be able to competently represent the client. Now, I'm lucky that I have funded fellows who are former students who have been with me, and they are going to have a role at the trial. So what my students at the trial will do is they will be journaling, they will be, obviously observing, and at the end of the case here in the U.S., what we have to do is draft findings of fact and stipulations of law. And so we're going to position them so that they're listening to the trial and able to do the first drafting of those stipulations. So I think that we have to, if we're going to do complex litigation, I guess my answer is we have to broaden what we accept as the learning experience to include that we are modeling for the students by our behavior, as do senior people in the Australian and Canadian system when you're doing the argument. You learn so much by watching really good people practice law. So that's my response.
Thank you very much. We should finish if we want to start with the second panel. I would like to thank first the University of Maryland to let us organize this workshop within this colloquium, and I have to tell that it's an honor and a privilege to start the project of the Academy in Maryland, because as you will see, the Environmental Law Clinic in Maryland has a wide history, and they will explain also to us all the troubles and problems they had in the past, and I hope not currently. Thank you for attending this first panel, and we are going to, yes, so.